If this is your first time joining us, my name is Melissa Rogers, and I oversee business development for Heritage Property Management Services. If you are returning, we are so glad that you're back. Thank you so much, and it's so nice to see you again. Friends, tonight we're going to be talking about some pretty heavy stuff, so I need all of your listening ears if you don't mind. I'm going to be joined by attorney Kimberly Gaddis of Gaddis and Lanier LLC, and tonight she is going to take a very educational approach to understanding the Act and its application toward community association management. I just want to remind everybody that Heritage University is actually open to anyone and everyone that is interested in understanding community association management. We will not be reviewing any Heritage or Gaddis and Lanier operations. Tonight, we are solely focusing on understanding the Act and giving you the information so that you can be prepared to hit the deadline that is rapidly approaching. As always, all of our questions are going to be held until the Q&A session portion of this evening, but please, as Kim is talking, feel free to submit your questions in the Q&A box in the upper left-hand corner of your screen, and we will go ahead and address those as we get finished for the presentation. Now, I know many of you are going to have a lot of questions, so if you wouldn't mind, patience, please. Kim has a lot of content she's going to need to cover. I almost assure you, if not almost 99%, if we can get through her presentation, she's likely going to answer a lot of your questions. However, I understand there are going to be a tremendous amount of questions because guess what, friends? She and I have them too, okay? Trust me when I tell you, and she's going to really kind of hone in on the process of what she's done to kind of put together this presentation. And so we are so blessed and we are so grateful that she has decided that she was going to join us for this wonderful journey on understanding the Act. So I now introduce all of you to attorney Kimberly Gaddis.
Good evening, everyone. Thanks so much for having me. I really am appreciative of being able to be here tonight. I appreciate Heritage Property Management Services and this great platform that they've created with Heritage University that allows business partners like me to come on and provide some information to all of you homeowners associations out there, board members, and vendor partners about important topics like the Corporate Transparency Act. I first learned about the Act earlier this year, and was interested in it because I knew it might affect a lot of our community association clients out there, but also as a small business owner with my law firm is a limited liability company. It also affects me personally, and probably many of you who are out there who are in HOAs as board members or who have small businesses of your own. So I want to go through, it is a lot of information to unpack here in the hour that we have. I'm going to go through quite a few things. So let's go ahead and get started. If we could, maybe just go to the next slide, Josh. All right, so some of the things that we're going to go over tonight are the legislative history behind the Act itself. Just a brief overview so you understand what we're talking about, why we're here, and why it's going to affect you. We are going to talk about who must comply, what reporting companies are, and what beneficial owners are. Those are the two main entities and kind of definitions that you need to know about tonight and how it affects you. We're going to define the reporting requirements, and then we'll go over the filing and submission processes, both on FinCEN.gov or third-party operations. I'll go into that a little bit in a few minutes. And importantly, what the deadlines are for being in compliance, and the penalties and board compliance requirements. We go to the next slide. So the Corporate Transparency Act really kind of came about quite a while ago in the early 2000s as a way for Congress to address concerns regarding small companies, shell corporations that were being used for illicit activities, money laundering, tax evasion, financing of terrorism. The first iteration of the bill came out in around 2006. It had bipartisan support, and it has been gone through several versions with a lot of backing that came strong in 2018 and 19. And it was eventually included as part of the 2021 National Defense Authorization Act. And it was put together really as an anti-corruption goal, a statute to effect, to help keep integrity in the financial systems and to require beneficial ownership reporting. So reporting of owners of companies that have long been required to report for large companies and financial institutions, but have not been required to report their ownership information in such detail as this until recently with this act. Next slide, please. So FinCEN, as its kind of its shortened name, is the Financial Crimes Enforcement Network. It's part of the U.S. Department of Treasury. It is designed, it's really a database. You'll go onto it as part of a website, but it's a database that collects, processes, and analyzes financial transactions, and it reports suspicious activity. It has oversight and regulation of the Bank Secrecy Act, and it is responsible for maintaining this database of beneficial ownership information that will be submitted by reporting companies. Again, it's designed to prevent the misuse of shell companies for illegal purposes. And Congress has named it has stated it's a crucial role in protecting the U.S. financial system from abuse. Next slide, please. So you'll see as we go through tonight that reporting companies is the most important thing that you're going to deal with. A reporting company must file with FinCEN and provide information on its beneficial owners. Those are two kind of key components of the Act. And let's get into what those are. If we could go to the next slide. A reporting company is any corporation, a limited liability company, or a similar entity that is created by filing with the Georgia Secretary of State's office or with any state throughout the country. It's really key that the Secretary of State is, if you are filed or registered with the Secretary of State or with a tribal government, if you're in a tribal reservation, then that would apply to you as well. But so small businesses, profit and nonprofit corporations, limited liability companies, and homeowners association, HOAs, POAs, and condominiums. In Georgia, almost all of them are created under the Georgia Nonprofit Code as a nonprofit corporation, and they would be deemed as part of the definition of a reporting company under the Act. Next slide. You'll see this is kind of small text here, but I wanted to get this all in on a slide for you so you can use this after the presentation. There are 23 express exceptions to the reporting requirements under the Act. Community associations are not one of them. There have been lobbying. There's been attempts to, try to get HOAs and property owners associations and condos to be deemed express exemptions from the Act. Those have not gone anywhere so far, and they are not exempt to date. But you should know what these 23 exceptions are. There may be some HOAs or community associations that fall under a couple of these exemptions. If you happen to have a 501c3 corporation, I do have actually one association that has filed for that exemption as a nonprofit exemption, and they would qualify for this, and also some large operating companies. Like I said, a lot of large businesses under the banking industries and financial institutions have already had to use other services, other filing reporting agencies to provide their beneficial owner information. So they don't come under this Act. And a large operating entity that has 20 full-time employees, over $5 million in gross receipts, and has an operating presence in the U.S., falls under an exemption. And I actually have a client that is an HOA, a large HOA that's almost like a resort in North Georgia that probably will qualify under this exemption. So look at these after this presentation and see if you do qualify for one of these exemptions, but most community associations will not. If you go to our next slide. So that does mean that this Act does have an impact on the nonprofit community association world. Our community association reporting companies, the answer 99% of the time is going to be yes. It applies to associations, HOAs, condos, anything that was created, incorporated, or filed under the Georgia Secretary of State's office. A question has come up is, are management companies or vendors reporting companies? And the answer is likely yes, in many cases for themselves, but not as part of the community association. So your property management, your community association manager, vendors that work for community associations are not likely going to have to come under any of the reporting requirements as beneficial owners, because we'll get to that in just a minute as to what qualifies as the definition of a beneficial owner. But they may have to file, because if you're a management company or a vendor, like I said earlier, if you are a small business of any sort that is registered with the Secretary of State's office, you likely will have to comply with the act and register your company as a reporting company, and then file the beneficial owner information with FinCEN. Next slide. So who are the beneficial owners? Once you've determined who the reporting company is, and in our case, it's going to be the community association, and we'll talk about what has to be reported with the company name, the association name, then we look at the beneficial owners of the company. And that is any individual who directly or indirectly through contract or relationship either exercises substantial control over the association, which is what in most cases is going to happen with our associations, or it owns 25% or more of the entity. So if you go to the next slide, please, you'll see that substantial control under the Act refers to individuals that have significant influence over the decisions and actions of the company. This will likely include all board members and officers, because they have the power to make the decisions on behalf of the corporation. As probably all of you know, and we tell our clients all the time, community associations are governed by their boards of directors, and all corporate decisions are made by a majority decision of the board. So those decision makers are board members. Sometimes they can also be officers. Sometimes you might have bylaws that allow officers to be named in the corporation that are not necessarily board members. But if an officer who is not a board member is named in the Secretary of State's office and also has decision-making abilities under the bylaws or the corporation, they likely will be deemed beneficial owners as well. So anyone who has the authority to make major decisions on behalf of the association, such as approving budgets, signing contracts, managing the day-to-day affairs of the community, those are going to be your beneficial owners, because they have substantial control. Advisors don't necessarily, they might not even have a formal title, don't necessarily come under substantial control. If a board delegates, authority to an agent like a management company or a manager, they probably are not going to be deemed to have substantial control over the community, because they're taking direction from the board. They're not making decisions on their own. But some large scale corporations might have a general manager or an executive director who is empowered with certain decision-making processes. They might come under the definitions of substantial control, so they might need to be reported as well. You have to look at your individual situation. You can certainly check with your attorneys and see if for your community, if you feel like there's somebody outside of the board of directors that you need some guidance on as to whether or not they need to be included in the reporting requirements. Next slide. Okay, so again, examples of beneficial owners are boards of directors on the board, yes. Officers, yes. Committee members, no, likely no. Committee members really are appointed by the board of directors. They serve at the pleasure of the board. They often will provide reports, guidance, recommendations to the board, but committee members don't make decisions on behalf of the association without the board's control or authority. So they are likely not going to be included in the beneficial owner reporting requirements. Also employees, again, except for some of the general managers that I talked about, perhaps of a large scale development. And again, your community association managers, your CAMs, your PCAMs, they are likely are not going to be required to be listed as beneficial owners for your community association. All right, next slide. So it's important to know, now that you know who are the reporting companies and what the beneficial owners are, that each association will be doing one filing with FinCEN. The report will include identifying information about the company itself, and then it'll have to include identifying information about those beneficial owners. The next slide will tell you exactly what you are required to report. That includes the full legal name of the board members, their date of birth, their current residential address, and an identifying number. The identifying number can be a passport number, a driver's license number, a FinCEN identifier, which I'll explain in a minute. And you have to have a document that coincides with that number so that you will be uploading the document that shows the number. I've been asked numerous times by clients, do we have to give our social security number to FinCEN? And the answer is no. There is a drop-down menu that you can provide your social security number if you want to. It is absolutely not required. I did the filing for my own law firm, and I'm going to go through that process with you here tonight. And we didn't provide social security numbers for myself or my partner. We did provide our driver's license and our driver's license numbers. So you need to decide if you want to do this filing yourself as board members, whether you're managed or self-managed by a board of directors. There's going to be a couple options for you on how you want to file, which we'll go over in a minute, but you can file yourself online. And this is the information that you have to provide for your association and the beneficial owners. If, as board members, you do not want to provide your passport or your driver's license to another board member who's going to have to upload all of this information into the system, since it's only one report, one person has to do it for all the board members, whether there's 3 of you or 5 of you or 7 of you, one person has to do the reporting. So FinCEN allows you to get a FinCEN identification number on your own as a board member. And if you go to the next slide, I'll show you a little bit about what that means. This is a screenshot of the actual FinCEN, the Financial Crimes and Enforcement Network website for the beneficial owner information site. It's pretty clear and easy to understand when you go onto it. You'll see some of the things here that are on the first page. If you have questions on preparing to file, you can go here. It'll tell you, answer your questions on how do I file? Do I qualify as for an exemption? And how do I get my FinCEN ID? You can create your own FinCEN ID by clicking on this link when you go to the website, and it will show you, it'll take you through the process, which I'll show you on the next slide, of what information you need to provide. You want to go to the next slide? So as a board member on your own, you can go to the FinCEN website, FinCEN.gov. You can register as a beneficial owner and say that you want to get your FinCEN identifier. You're just going to create an account with your own name, your own address. You will submit your own personal data to FinCEN directly. So you'll provide your name, your date of birth, your address, and then you will have to provide either a passport or a driver's license or a state ID. If you don't have either one of those things, just a state identification card would work. You provide that number, put it all in the system in the fields. You will upload a copy of your passport or your driver's license. It'll take it right away. And then the FinCEN database will issue you your own FinCEN ID, and it happens immediately. I did it, like I said, for myself, put it all in. It pops up and gives you a FinCEN number. And then you can take that number, and that'll be used for yourself, for as long as you are associated with any entity that needs to report. You can provide that number to the person that's going to enter it into the website for your company. So every board member could do this on your own, get a FinCEN number, and then say you want the board president to be the one that's going to file for you. You provide them with the FinCEN number, and then rather than having the board president enter your name, address, social security, or passport or driver's license number, they would just they would enter the FinCEN number when it comes to entering your information. Okay, next slide. So like I said, when you go to have to submit the information to file, you can either use the FinCEN website and go online directly. You will provide the person who is the submitter, who has to is submitting all the information on behalf of the company, has to fill out their name, their address, and then you will provide information about the reporting company. And the reporting company for the association, you will need the association's full legal name and the EIN number, the federal tax ID number, the employer identification number. Every association should have one. I tell my clients all the time, even if you don't have necessarily pay taxes every year, if you don't make money, as an association, but if you don't make a profit necessarily, but you should be filing reporting your taxes every year as a corporation. You should know what your EIN number is. You can get it from your manager, or if you're a self-managed board, you should have that information somewhere, maybe with your CPA. And you will have to give the association name, their EIN, and a physical address for the association. Some associations might have questions, what if we don't have a physical address? If you have a mailing address for your clubhouse or a mailing address for some, mailbox center in your association, you can use that. Or you may have to use a board member's residential address. If you're not managed and you want to fill this out, you have to have a physical, you cannot use a PO box. There has to be, the whole purpose behind this is to provide reporting information and identifying information for both the company and for the beneficial owners, the board members. So the board members can do this directly, and all you'll need to do is to decide which board member will submit your information and how you want to provide them with that information, whether you want to use your FinCEN ID number or you want to give them your information directly. Or you can use a third-party secured portal, third-party vendors. There are a ton of entities that are doing this out there that will be happy to help you with it. Management companies, CPAs, data security companies. You could Google FinCEN reporting, entities, and they will. There's just a ton that will come out there in your area. And you can find out information about how to do that. But I just want to kind of go through with you, in the event that you do it yourselves, how that works. So the next slide, please. So here is another screenshot. Again, welcome to the beneficial owner information e-filing system. This really just shows you, once you get on, you can simply go to the Get Started link. And once you click on it, it walks you through a series of steps on how to comply with the Act and the reporting requirement. If you go to the next slide, you'll see there really are between 4 and 5 steps for filing. Most associations are going to have simply 4 steps. This is another screenshot from the website. As soon as you click on the Get Started button that I just showed you, you'll see that there's filing information that you're going to start with. If this is the initial filing, the initial report, you'll click on that. And every step will show you a little next button. It'll tell you what you need to do. And then it'll have information on the reporting company. Like I just said, it'll ask you for the association's name, the address, the EIN number, and it may ask you for your name as to who's inputting the information. The next step would be the company applicant. If you're not a brand new company, if your association was incorporated prior to January 1, 2024, you're not going to have to fill out this company applicant information. There's a checkbox on there that you can say, it'll say, are you an existing association or existing company? And you click that mark, yes, if you were created before January 1, 2024, which 90% of people on this presentation probably are. And then it's a little confusing at that point, because it kind of blocks off all the other fields on that page, but you're trying to input, information, but it doesn't say, skip or go to the next one. So finally, you just have to hit the next button. It'll take you to the next tab. But if you were incorporated before January 1, 2024, you don't have to put in company applicant information. If you're incorporated after that, if you're a new corporation, some developers may have this issue. If you're creating an association for new development, you're going to have to put this in. And any company that's created now, within 30 days of being incorporated, they're going to have to fill out this information and comply with the Act. So that was where you'll put in your company applicant information, and that is either the incorporator of the company, like your limited liability company or corporation, or it can be the lawyer, the incorporator, whoever is creating that entity for you. And then you finally are going to hit the tab under next for the beneficial owner information. And that's, like I said, we're going to put in that board members' names, address, date of birth, and their identifying number on driver's license, passport, or their FinCEN number. And once you've done all that for each of the board members, whoever's filling out this website report will then hit submit, and it will take you to a certification page where you will, basically certify that everything that you're submitting is correct. And it'll immediately give you a confirmation number and tell you that you've completed it, if it was successful, if there's anything wrong with it. There was a couple steps where it will ask you, kind of like if you're filling out, any other documents online, if you've missed a step, it'll come back and say, error, and it'll be a little red red line showing what you forgot to fill out. So then you can click submit OK. And then it says it'll send you an email. I thought it would be immediate. It wasn't. I didn't get the email confirmation saying it was successful until the next morning. So don't be alarmed if you don't get that right away, but you will get the confirmation on your submission. And in fact, it'll say, print off this information or upload it, download it, keep it in a safe place, excuse me, which we'll talk about in just a second. So you want to keep that with your corporate records. So if you go to the next slide, you'll see that some of the submission considerations that are important if you do this on your own. There's two sources of submission liability. One of them is submitting the correct and complete information, and another is holding and storing the personal identifiable information for each of the board members. So the next slide just gives you some common sense information on how to safeguard the PII, the personal identifiable information. Of course, you should use secure websites. When you're going on to the FinCEN website, it is a secure website, but make sure that when you're doing it from, a laptop or a desktop that you are familiar with, that you have password protection on, that you can keep all your information in a secure and safe place. You know that you're going to have people who, you have limited access to this. You should keep it on you can keep it on a secure cloud storage. You want to make sure that, any other corporate records that you have for your community, if you're self-managed, yet you're keeping backups of your information. In this situation, you're only collecting the data that's absolutely needed, and that you're using strong passwords and, protecting your corporate data in the event of potential data breaches. So all of our board members, for all my clients, deal with this kind of thing on a regular basis, whether you're dealing with insurance documents, contracts, corporate information, bank accounts, ledgers, statements. You should just treat this information in the same way that you would treat all of your important data. Next slide, please. So this is kind of a recap of the next steps for compliance. You need to identify the reporting company, which is going to be your community association, identify your beneficial owners, prepare the documentation. And so like when I did it, we just made copies of our driver's licenses for my partner and I. And luckily, it was simple for me. There was only two of us. And then we just pulled together our information for our names, our date of birth, our addresses, all of that. So you'll do that for all of your board members. And then you want to make sure that you are going to timely file your reports, because I will get to that in a moment of what the deadlines are. If you just go to the next slide, you'll see kind of a recap of this as well. Again, I wanted to provide some slides so that you guys can use this after this presentation. The access the FinCEN portal, which is www.fincen.gov. You're going to register your account for your association. As I said, you'll need your EIN and your physical address, and you're going to gather all the required information for your board members as your beneficial owners, and provide that to the person that's going to be filling out the information for you. You'll complete the task once you've gone into the website, submit your report, and then you're going to save your information in a safe place. Can we go to the next slide? So the compliance deadlines are important, and that's why this topic is coming up right now. It's kind of a big deal for everybody, because I think a lot of people were hoping in the industry, me included, that we would not, that we'd be exempt as community associations from these deadlines, but we are not. So the existing entities must file these reports by January 1, 2025. So really at the end of the year, December 31st, you should have had this task completed. New entities must file within 30 days of formation of a new corporation. This will apply to new developments for sure. If you're a developer creating an association, you're going to need to do that within 30 days of that incorporation. And thereafter, you only have to update your information if there is a change. So for most of our associations, though, it's going to be annual. Most of my communities have board members, at least one board member that changes every year. If you have staggered terms, sometimes you have all the board members changing every year with elections. So you should plan on having to do this update and reporting annually, but certainly also within 30 days of any change in a beneficial owner. So if you have board members who resign, or who, you have a vacancy, someone who's moved out, you are going to need to update that information and change it if you have appointed a new board member to fill that vacancy within 30 days. And failure to meet the deadlines can result in some significant penalties, unfortunately. We'll go to the next slide. I'll go through that. So there's penalties for both the reporting companies and for the beneficial owners. So you should be aware of that. There are civil penalties for willfully failing to file or for providing false or incomplete information. There's civil penalties of up to $500 per day. So it's pretty stiff. And there's criminal penalties for willfully, again, submitting false or fraudulent beneficial ownership information or failing to provide timely updates. You can have criminal fines of up to $10,000 and even imprisonment in severe cases. This is in the statute, so you must know that there could be imprisonment up to 2 years. So it's a federal statute and they take it seriously. So the reporting company has those, as well as on the next slide, you'll see the beneficial owners themselves also have these penalties under the statute. So you need to be aware that if you are someone who just feels like you don't want to comply with this task, you don't want to provide your information as a board member, you certainly have the right to not do that and decide not to be on the board anymore. You certainly can resign if you like. But there are civil and criminal penalties for failing to provide this information. It is a requirement under the law. And you could be hit with individual fines and criminal enforcement actions if you don't provide it. And in fact, the next slide, if you go to that, will explain a little bit about that. So we've had questions that happen, what if board members refuse to provide the information? It is very likely going to be deemed a breach of duty of a board member if you intentionally withhold information or refuse to provide it or refuse to comply with the law. It's no different than if you are suggesting that you're not going to uphold the covenants or you're not going to, obtain insurance for the association. You're not going to collect assessments. There's certain things that you can't do. If you want to be on the board, then you have to comply with the law. And so this is one of those things. So you are welcome to something just happened on the screen. Okay, so you're welcome to decide that you don't want to be on the board anymore, and that's perfectly fine if you don't want to provide this information. But most of my associations that I've been talking to are providing the information because it really is pretty innocuous information. It's just your driver's license and your date of birth, and it is going to be secure in the FinCEN website. There are only certain things that FinCEN cannot just distribute the information to anyone. They do only use it for law enforcement purposes. And so it's just a reporting requirement that really you're going to look at kind of like when you have to provide your information to the Georgia Secretary of State's office every year. Granted, this is a little bit more information than the Secretary of State's office requires, but it's just, you're going to have to look at it as just another thing that you have to do as part of the reporting every year. So there are questions about also what can we do if someone refuses. You have to look to your bylaws to see what the removal procedures might be for your boards. We've asked some of our clients have asked us to talk about amendments to bylaws to require that board members can be removed by a vote of the board alone and not by vote of the members if they fail to provide the information. And my partner who does some developer work is actually including that in her bylaws, new bylaws that she's doing for corporations right now for new associations. And it's going to be an automatic requirement, a removal process if you fail to provide the information. So you need to look to your individual bylaws for removal procedures, and you can talk about amending your bylaws if that's something you feel like is important for your community, if you think it's going to be a problem. But hopefully, for the most part, it will not be, and you will be able to comply with these requirements every year. The next slide, please. So there have been some legal challenges. There definitely have been issues that come up regarding privacy concerns, administrative burdens. There's been several lawsuits that have been filed against the Department of the Treasury, trying to make the whole act unconstitutional. There's been actually some differing decisions that have come out across the country about that are on appeal. Even the Community Associations Institute has filed a lawsuit against the U.S. Department of Treasury. I've cited it for you here on this slide. And they're just seeking essentially to have, in our case for community associations, to have us listed as exempt entities. People will say that the legitimacy or the purpose behind the act may be, needed for large financial institutions to prevent, money laundering and tax evasion and things. But the likelihood of community associations being involved in that, some would say, is small. So there's still hope that we can maybe get some kind of ruling after this lawsuit that the community associations might be exempt in the future. But especially because of the administrative burden on having to file every year, because board members do change so often, whereas other small businesses, like limited liability companies, so you might have one or two member companies or small corporations that are family owned, that aren't going to change every year. That is a much lesser burden on them than having board members that we know are going to be elected and change every year. But right now there are no changes to the applicability of the Corporate Transparency Act to community associations. So you need to be aware that this deadline is looming. It is coming up. I would take it seriously. I would make sure that you do everything you can to come into compliance with the act so that you don't, potentially get hit with any of these enforcement mechanisms. Next slide, please. Okay, so these are kind of the key takeaways. I know I've gone through a lot of information in kind of a quick fashion, and we are going to have some time here in a few minutes for some Q&A, and I'm happy to answer questions as they come up. But so you really need to know that community associations are not exempt. Board members must comply or face some major penalties or removal from the board. And ensuring compliance with the CTA will help make sure that your community association is operating within legal parameters, and that your association will not also be hit with penalties. So if you want to go to the next slide, that's just my information. I know it's a lot of highlighted information in pretty quick, shorter period of time, but I want to give you guys some time to also ask questions if we have any.
I love it. Thank you, Kim. This has been a ton of fun, or at least I think it's been a ton of fun. You and I have had a great time putting this course together. I recognize, and we both recognize, this is very heavy information. And we've received some very great questions. I want to say thank you to everybody who has stayed to listen. I'm just going to go ahead and start with some of probably the most resounding question that we're getting back behind the scenes is, do we have to do this even if we're self-managed? And I love that question, because this class is for you.
Yes, that's exactly why I wanted to get these screenshots in there. I wanted to kind of reiterate more than once how you go about filing on your own. So if you are self-managed, yes, you have to still file, and you have to do this, on your own, or potentially find, a third party out there that is just a corporation that might help you with it. But this is really important that you comply and that you report.
So you just, in one of your last or closing slides, I should say, you did bring up the difference, which as a managing agent, we are getting a lot of questions from our partners about, well, do I still have to register for the Georgia Secretary of State? And I'm already going to say, yes is the answer, friends. Yes. This is a federal filing versus a state filing. And as a subsequent question that is also starting to come up, just as a quick delineation, the Georgia Secretary of State is an annual filing regardless of changes or no changes. Right. That's a big difference and again, it's kind of like what we told our CAMs when we were talking about this. This is like 2024 vision. We still have 2025 vision that we also have to address, which are the changes and what constitutes a change and how quickly you have to have all of those in. So for right now, focusing on the things that are the most important, the information is, yes, this is real, just like what she said. The Georgia Secretary of State is its own thing that has to be filed separately. And boards, think of it just like the Georgia Secretary of State. You have to file it, but there's a little bit of difference, right? The Georgia Secretary of State only requires the 3 officers. Here, with the federal filing with FinCEN, this is where all board members are now considered based on the information. So just putting that out there. And Kim, if you wouldn't mind, can you just readdress that how FinCEN filing works and that if there's no change,
Yep.
what happens?
So yeah, once you do your initial reporting,
Mhm.
like I did mine just the other day, quite frankly, you
Right.
go on, you type in all your information, you create the filing, you create an account for your corporation, for your association, and then you add in your beneficial owners. For me, I have my partner and myself, and we are not going to have any changes in foreseeable future to our company. So I'm not going to have to make any changes. I'm not going to have to refile next year. It's only if there's any changes to your beneficial ownership, if somebody else comes in and has a 25% ownership of your company, or in the case of boards, the substantial control, if the board members change in the middle of the year or at the next reporting year. So every year your deadline is going to be the end of the year. So it's kind of like the Georgia Secretary of State, again, is a separate state filing requirement. That does require you to put just the officers in, and that reporting comes at the beginning of every year. And I think the deadline is like maybe April 1st. I kept,
Yep.
yeah. So this one though, you're going to have to file by the end of every year. So for 2024, some people have already submitted. I filed for my 2024, and we are compliant now. So if there were any changes in 2025, I would have to do it by the end of the year 2025.
Awesome. So, and thank you so much, because that distinction right there probably sums up a lot of the questions that we had from anybody in the audience, which you have all submitted such phenomenal questions. I really appreciate it. Let's go back to the BOI and who's a BOI and why is a BOI. And you did such a great job. I love the slide where you gave us the legend that says yes, no, yes, no.
Yes.
And so when we're dealing with an association or possibly new development, which you and I talked about this, I want to pull my hair out for these new developers, and not because of them, but because of the reason why I'm about to ask this next question, which a lot of people are asking. And I just want to let you know, friends, this question is a legitimate one, whether you were built in 1976 or you were built in 2024, okay? The difference is, and this is where Kim was coming into it, is Kim, what happens if I'm in a 10-unit association and I have no common area, and the association, you and I both know, have a P.O. box down at the mailbox, which is where they receive their payments. And you just told me, if I heard you correctly, that you can't use a P.O. box. So then a question that just popped up is, what do we do if there's no physical address because we've been using a P.O. box? What do we do in that situation?
Yeah, that's a really good question. And actually, I've been on, FinCEN has a Q&A, a huge Q&A link that you can go on to, and it's updated on a regular basis. Actually, I signed up, subscribed for updates, because it actually, some of these answers change, or new questions and answers come in. So I did, and you can call FinCEN as well. I called them and asked them some questions myself. And there's not a really great answer right now for what you do if you do not have a physical address. I know condos may have a problem with this more so than maybe some HOAs, if you don't have an actual physical address where you receive mail at your community, I don't know exactly what the answer is yet. I know that I was told when I called FinCEN that board members can use their physical address, their residential home address. And most associations, even with condos, will have some kind of residential mailing address, even if it has a unit number associated with it. That's fine. They just said P.O. boxes in particular are not authorized, and you're not technically supposed to actually use a third-party management company as your address as well. So I'm happy to review and see if I can get some more information. If there really is no physical street address that you can use, even with a number. You might be able to go to the post office and get one for your clubhouse or something. But that's going to be something you'll have to look at. For reporting purposes now, you're going to have to put in some kind of physical street address. And if you need help, maybe check with your management company or your attorney if you need help, if you actually don't have any kind of physical address you can use.
And let me tell you, friends, that's been a fun exercise to figure out, because we are starting to help some of our partners register, and boy, oh boy, this has been a fun one for us. And I'll tell you, I've got some really smart managers that are sleuthing, and they're like, oh, we can use the utility address, or we can do this.
Yeah.
And I'm like, yes, I love how your brains are thinking. But at the end of the day, friends, here's the caveat to what Kim just said. It doesn't matter how you're filing it. Third party, independent, Joe Schmo in a truck. It doesn't matter how you're doing it. You got to know what was submitted so that you know what triggers the change. Because just as what she just said right there, if there's no change to her law firm, practice, the address, the partners, because the partners in this circumstance are the BOIs like she talked about, okay, then nothing has to change. But as we're talking about for all of you, you guys don't live in a perfect world. Are you kidding? Sometimes there's only 2 of you, and sometimes there's 12 of you. And right. I'm going to tell you that there's an association that I know has over 20 board members, okay? And so we're talking to all of those that have various amounts of people. We are bringing this course to you because she and I have been like, holy smokes, here are the forks in the road, friends. Here's what we're finding is the issue. And we're just saying, hey, guess what? The best place to go get your answers, it's FinCEN.gov. It's not an attorney. I mean, although sometimes they'll help you with the composition of your board. Okay.
Right. We can help with some legal requirements or compliance. Right. But yeah, FinCEN.gov will tell you exactly, they'll answer tons of your questions. And I'm glad you brought that up, because the change is not just a change in board members. If a board member who's on the board changes their address in the middle of the year, say they move and they get a new driver's license, they have to go on and update the FinCEN website within 30 days of that, because their beneficial owner information has changed. So it's really important that you do keep up with that.
Marriage, divorce, address change. Yep. And I know you were all going, wait a minute. So I kind of think about it like this. Whatever you need to go to the DMV, that's what you need for this, just minus any utility bills. But, when you're having to change your name, or when you're changing your address and you have to go update your license, this is the kind of similar thing. So just some of those triggers that constitute changes. And so a lot of the questions that we're getting, do you have to do an annual registration for FinCEN.gov? And the answer is it depends. Technically, if there are no changes, the answer is no, because you're just doing the initial filing, and all is good to go until a triggered change is required. And to all of the things that Kim is lovingly talking about, because you are all smart and you registered for this class right here, we are going to give you so many resources and so many goodies so that it doesn't matter what you decide to do, who do you decide to do it with, or whether or not you have 2 members on your board or you have 25. It doesn't matter. We want you to have this information, and you're going to get all of that stuff. So those were really big questions. We had some questions again about what happens if we have board members changing. And so this is where we talked about, you did such a great job. We had another one of those questions about, we did have a question, what's the benefit of using a third party versus doing it yourselves? So, I don't necessarily want to go into that technicality, because again, like I said, this is more about understanding the act itself than talking about whether or not there's a benefit. But here's what I'm going to tell you. Not all associations are created equal, because we know this, friends, right? You are all beautiful snowflakes. None of you are created equal. And those governing documents are, sorry, Kim, I love you, they're wackadoodle most times, okay? And so keep those things in consideration when you're looking at this. And so, when it comes to whether or not you should do it yourself, it's your time. How important and how much time is it going to take for you? I can't tell you that. Kim can't tell you that. I can tell you what the average has been taking me, and you don't want to know the answer. Okay. Like I told Kim, I said, Kim, you registered 2 BOIs. It was lickety split. You had the stuff done. You were prepared and ready to go. You know that's, small percent of our associations. Okay.
Right.
Because
And I
you
know
are going
my
to,
situation isn't going to change. So yeah, as a board member, you really have to think about, do I want to be responsible for me or someone on my board having to keep up with this and go forward with any changes, or keeping up with the information, the identifying documents. So it really is a consideration you have to look at and see there, because, having the ability for every board member to enter their information separately through a private third-party portal might be the way that you want to go. It really is. These are options you need to look at as a board and decide for yourself.
So, and this too is a great distinction. Thanks, Kim. This is the difference between the Secretary of State and the CTA. The CTA is like taxes. You have to get them done, but you have options on which vendor you can choose to do it. Friends,
Yeah.
this is exactly the same thing, which is why we're bringing it to you like this and not focusing on the actual specifics. Because again, as Kim said, there's probably going to be, your bylaws are also going to be incredibly crucial as to what you can do with some of these things. Okay, so thanks for helping to answer that.
Sure.
What happens if our HOA has 0 employees, Kim? Do we still have to file?
You do. So even if you have no employees, employees don't matter to the CTA. It's the beneficial ownership, which is the board members of your association, who have to report their identifying information. So the government is looking for who controls this entity. They want to know, think about it. If you're looking at, trying to fight crime, if your goal, if the end goal here is for the government to be able to identify somebody who is, funding terrorism or money laundering, getting to the corporation. I don't know, to get too much in the weeds. It's hard to sue a corporation if you don't know the owner behind the corporation. It's hard to criminally, indict somebody who is involved in crimes if you don't know who they are, because they're hiding behind a corporate name and a PO box. That's the whole purpose behind this, is to know who is controlling the association, and the controlling people of the community associations are the board members. So the employees that they hire don't matter. It doesn't matter who your CPAs are, or your lawyers, or your landscapers, or your insurance carriers. It really is the board members that this act is trying to get at, and who you need to report to.
Love that. Great answer. Thank you. This is a good question, and it kind of follows in suit to a little bit what you were just talking about. And this has been coming up a little bit. And you had mentioned, and I don't know that enough of the audience caught it, but going back to the portion that you were talking about, the reasonable effort in compliance, or making that attempt in filing, or versus not doing it.
Right.
Are all board members on the hook for non-compliances with changes? So if you're on a 3-member board and you did everything that you were supposed to do, and Susie Q got married and didn't trigger the 30-day change, is the board in trouble?
Well, in all likelihood, no. Not every beneficial owner is going to be hit with penalties. And, again, you have to look at it, and hopefully the government will do this as well with the use of common sense. I don't think they're going to come after you, with a $500 a day or $10,000 penalty because you failed to, notify them of a change in your, in your marriage certificate within 30 days, or on your driver's license. But just know that these are the requirements. So as a board of directors, you have to do due diligence in making sure that if you are aware that there is a change in circumstances, a change in name, a change in address for a board member or a group of board members, then you need to report it. So the compliance, again, the enforcement penalties are out there. They're in the statute. We don't know, because no one's been hit with any penalties yet. People are still have until the end of the year to comply. So hopefully the government is going to, have some leeway and use some common sense. It is important to know that, though, when I did some research and I've talked to FinCEN about this, that the absolute failure to report is a higher penalty. It's deemed more severe than having some inconsistencies or some problems with your reporting. Because if there are problems and you discover them, these are completely updatable. You can amend your filing and go in and correct it and likely not face penalties or as many penalties as if you're knowingly and willingly failing to comply or filing false information. Obviously, those are going to be hit with much more enforcement penalties.
And so, just for clarification, because I don't know that I did a good job of distinguishing this when we were talking about the third parties, but let's just say this. Separately from the Georgia Secretary of State, which has an annual filing fee, there is an annual registration fee with the Georgia Secretary of State, come heck or high water, no matter whom does it or what management company or other vendor does it. With FinCEN.gov, there is no fee if
Correct.
you are registering on FinCEN.gov yourselves. Again,
Correct.
this goes back to what I said. What is the price of your time, board members? Because just as Kim said, you need a singular point of data input. Yes, you can do some outside stuff, but then you still have to keep track. Somebody has to have all that information, and there has to be that filing. So again, she made it sound glorious. And it normally is. Hear me when I say it normally is. There are some times where it takes me and the team, 15 minutes tops, and we're like, woo, doing it. And then there's times where we're like, oh, stuff. Wow, we're going to have to sit and sleep and come back on that one. And really, it's been the physical addresses, friends. If I'm being fully transparent, the thing that has been really hiccuping us is the physical addresses, because to what we were talking about, what we understand it, they want to go boots on the ground to something. So of course, it would be reasonable if you're professionally managed to want to have your management company do it. That might constitute a change, especially if you're a developer, because I can put my address, but then once you get a physical address, then that constitutes the change because now you've given a physical address. So again, this goes back to who's going to keep track of that. Ultimately, board, it's your responsibility. It's not my responsibility. It's not Kim's responsibility. It's not the CPA's responsibility who you're hiring to do this. You board members, as BOIs of your reporting company association, must know this information. You cannot stick your head in the sand. This is why you are so smart and perfect and wonderful, and you registered for this class, and you're going to be able to share it with your friends. Okay. Kim, you're going to love this question as an attorney.
Okay.
Most covenants require board members to be in good standing. Yes, they do. Well, to be a board member, to be eligible to serve on the board. For those of you based on this question, can this good standing requirement be interpreted to include compliance with FinCEN reporting, or is it necessary to amend our covenants to include a FinCEN condition? I love this question.
Yes. So that really is going to depend on your bylaws, for one thing. Sometimes some bylaws are very specific as to some define what good standing means. A lot of them don't say good standing. They say the specific requirements for being eligible to run for the board are that you are not delinquent in the payment of assessments, or that you're not in violation of the covenants, or a covenant, or a rule or regulation. So that's a very good question. Our advice to our clients so far has been, you really need to be on the safe side. You really should amend your bylaws to make it a requirement that that this law be complied with in order to be eligible to run or to remain on the board. You can look at other provisions of your bylaws. Some bylaws might have more stringent provisions to allow for enforcement for failure of a board member to provide the information, could be a cause for removal. Some might not, quite frankly. So you really need to look at it. I don't think being delinquent or being, failing to provide the information is going to be the same as being deemed delinquent or necessarily not in good standing if you don't have a good definition of that in your bylaws. So it's bylaw specific. You need to look at your bylaws, check with your attorney if you have one. But in all likelihood, you're going to need to amend your documents if you want to make sure you have the ability to remove a board member who doesn't comply.
Remember, these are 2025 problems, friends. Let's get through 2024, okay? So with 2024 in mind, let's go to our next question because I'm getting this like a caboodle a bunch.
Okay.
And what I don't want to have happen, boards, is I don't want you all rushing until the month of December. Let's put our thinking caps on. What month is it? It's October. What happens for most of us? Annual meeting season, it's budget approval season. We're sending out coupons. The United States Postal Service is failing all of us at this moment, okay? And so think about the things that we're doing. Then it's the holidays. We got Thanksgiving, well, Halloween, depending on who you are, because, you know, Halloween, Thanksgiving, any other holidays that might be coming towards the end of the year. And think about all the other mailing things that happen because of, you know, Black Friday and all those other things. So think about how this is all going to kind of work in the times. And then for those of you that have ever used technology before, stuff crashes. Federal websites crash, okay? And so think about this, because in this next question, Kim, if I'm only a board member until December 10th, do I register or do I not register? What do I do?
So that is a very good question. And that is something that I have looked at directly with the FinCEN Q&A and have talked to them about it. So you are only required to list beneficial owners as of the date of filing, as of the date of submission. So if you know that you're not going to be on the board as of, you know, December 1st, because you're having your annual meeting and your term is up and you're not running again, your board could make a decision that we're going to file with the FinCEN website on December 10th. So it is waiting a little bit late. I agree. But if you don't want to have to re-report, that certainly is fine. You only have to report the duly elected board members as of the date of filing your submission with FinCEN. So you don't have to report anybody. If you ended your term on the board on December 1 and your association's filing on December 2, it's the board members who are elected and serving as of December 2nd.
Did you hear that? That was like the most crux question of all things. Thank you so much for answering that. That was brilliant. Okay, so another question, and this is going to go back into board composition, friends. This is, remember, and I will say some bylaws do delineate, Kim, the differences between whether or not a officer and a board member have to be elected from the ownership, and this is
Correct.
where this saucy stuff gets funky. So in that vein, what happens if I have somebody that we know is on the board but they weren't elected? Do they still have to file?
Yeah, that's a good question. So oftentimes, you might have board members who are appointed. You might have a vacancy on the board by somebody who's moved or just resigned. And most bylaws allow the remaining board members to appoint someone to fill that position. They don't have to be elected to serve the rest of that term, but they're still duly appointed under the terms of the bylaws as a board member. So if you are either a board member, and oftentimes board members under a lot of bylaws are appoint amongst themselves the officers of the association. And so they are one and the same. You might have 3 board members who are the 3 officers, or might even hold more than one officer position if you have 4 officers. Sometimes you have bylaws that say officers don't have to be board members. And I do have clients that have board members that have additional officers that are, serve as secretary or treasurer who are not board members. And as long as your bylaws authorize that, that's perfectly fine. But those officers are going to be deemed beneficial owners because they do have substantial control in all likelihood. If they make decisions, as treasurer, if they make decisions as secretary, you probably would be on the safe side to include those officers as in your reporting as beneficial owners, especially if they have any voting rights under your bylaws. So really, it's board members and officers with voting rights under your bylaws who have to be listed as a beneficial owner. But if you have that odd situation where you have an appointed officer who might not be a board member, I think it would be a good idea to list them, rather than not, because it's going to be very odd if you have a secretary listed with the on the Secretary of State's office with your state of Georgia, but they're not listed with FinCEN. I think it would make it look suspicious.
Gotcha. Well, thank you very much because that was great. And going back to the physical address question, because we've kind of talked about this a little bit, if we weren't very specific about this, if your association, 10-unit homeowners, going back to that example, and you don't have a physical address, it does need to be a board member's address. That's
Yes.
precisely. Whether you're self-managed or professional managed, even if you have a professional management company, if you have 10 homes and no physical address other than the units, then one of those units, if it's a board member, needs to be listed as that. So just to
Correct.
do a quick clarification on that, I just want to make sure that I'm not getting any other ones that we're missing, because I think we're kind of coming down to the wire on this, and we're like perfect timing. Thanks for everybody for staying for 5 extra whole minutes, because this is some great stuff. Not really, but yes, it is. And Kim, you've done just such a wonderful job in putting
Thank
all
you.
of this together and explaining it. I know you make it much easier for me to understand, and
Great.
at the end of the day, we'll put it to you all like this, friends. If you've got a question, ask FinCEN.gov. Yes, is your community association attorney specifically going to be there to be able to help you with guidance related to eligibility, who has to do it, compliance, all of those different things? Josh, I love your computer screen right now. That was so great.
I love it too.
So, from that standpoint, I do think that we are done with the Q&A for right now. So again, thank you to Kim. I just want to do a quick shout out to her. She's probably one of, and her firm is probably one of the first law firms to actually publish any guidance for associations on how to handle this. And so I really Heritage sincerely appreciates all of the effort and the hard work that you put into this. For all of you that are watching us, you guys know the drill and how all this is going to work. You guys are going to get all of your goodies more than likely tomorrow. And you're also going to get a nice follow-up email that's going to ask you, hey, did you enjoy this? Do you have some feedback? Do you still have a question? Not a problem. If we didn't answer your questions today, you will still have an opportunity to go ahead and ask us those questions in that feedback and that follow-up that you're going to receive tomorrow. And if you didn't read any of the stuff that's over here in the Q&A, yes, you are going to get a copy of all of this fun stuff. And because, like I said, you are all brilliant and exceptional community association management people, you're also going to get all of this information more exclusive than those that did not register. And this will be put up on our YouTube page once it's available, probably more than likely closer towards the end of October. Just to let you know, in the goodies of resources that you are going to receive, Kim kind of talked about this, but in the goodies of resources that you're going to have, we're going to give you FinCEN.gov's BOI FAQ. This is you want to talk about the answer key. Like Kim said, this thing gets updated constantly. And really, honestly, FinCEN.gov gets updated constantly. When we are going to also provide to you some additional information, we've included some stuff related to the Georgia Secretary of State just so that you can see what Governor Kemp has to say about it if you really need to see that too. And then there's going to be some other attorney resources that are available. Any other types of questions and things related to the Corporate Transparency Act. And of course, our favorite friends at Community Associations Institute, CAI, has done a phenomenal job. Not only are they phenomenal in advocating for us on a state chapter level, but they're also doing that on a national level with our Legislative Action Committee. So kudos to all of them. Those resources are also going to be made available to you afterwards. So if you need any information, if you need any resources, I'm sad to tell you, your manager is probably not going to be the best person to answer them. And also, most of your questions might be, it depends, but we're going to work with you on them. We're going to work through this together. The good news is we're all in the same spot at the exact same time. So you know what? We're going to figure it out. It's going to come to us. It might be a little messy. It might be a lot easier than we think. And we're going to look back at this and go, this is no problem. So thank you again for coming. I look forward to seeing you again in the audience very soon, and y'all have a wonderful evening.
And thank you so much, Melissa. It's been wonderful. I appreciate you having me. And
Sure.
it's been a great time. Thank you.